Hello, everybody, and welcome to Module 7, Unit 9, Real Estate Agency. And today I'm going to talk about the differences between being an agent or not. My name is Brennan Posen. I'm your instructor for the C&M course, and this is for the Modern Real Estate Practices Law portion of your pre-licensing courses. Now, I'm sure you've heard before the term agent, and you've probably even told people that you are going to become a real estate agent, and that is not necessarily true. We are going to be getting licensed to be real estate professionals and licensed real estate professionals. And some of you will be realtors, some of you won't be, some of you may be agents, some of you might not be, and some of you might just practice as brokers. So remember, here in New Mexico, we have a qualifying broker, which owns typically and runs the brokerage or is in charge of the brokerage. Sometimes they might be an owner, sometimes they might just be an employee, an independent contractor of that brokerage. And then under the QB lays the ABs, or the associate brokers. And those are the people like you will be after you get your license. You'll be an associate broker. And that just means that you have to have a qualifying broker to work under. Now, remember, realtor is a designation for joining a realtor association such as GAR. That would be the Greater Albuquerque Association of Realtors. And that just says that you're going to abide by a higher ethics and professionalism than that of a typical associate broker. So not all of you will be realtors. Some of you might just stay associate brokers if you're not going to be joining any association. Now we're going to get into what this course is actually about, or at least this module, and talk about agency and how it's created. Now, when you call yourself an agent, that means you have created an agency relationship with somebody. So remember, there's three standards of relationships with people we deal with in the public. If we have no written agreement with these people, with anybody, and we're still helping them through the real estate process, they are our customers. So everybody we deal with in the general public is a customer. If we have a written signed agreement with these people, typically that looks like a listing agreement or a buyer broker agreement, then we would have a client. So they're not our clients until we sign something with them saying we are representing them. Then we have our third category, which is agents. Now, agents are created by using an agency addendum, and that would then create a relationship with our client, and they would be now known as our principal. And when we talk about principal, your brain should automatically go, that means I'm an agent because it's principal and not a client or customer. And now I owe what's called fiduciary duties. I'm a fiduciary to my principal. And what this means is I owe certain standards of care and certain things to my principal. And the easiest way to remember this is an acronym called OLD CAR. So in your notes, you're going to want to write out OLD CAR. And under O, I want you to write obedience. L is loyalty. D is disclosure. C is confidentiality. A is accounting. And R is reasonable care. Now, those are our fiduciary duties that we owe to our principals. So we owe our principal obedience, we owe them loyalty and full disclosure of everything we're dealing with in the process. We owe them confidentiality unless that confidentiality is required of us to make disclosures by law or federal fair housing. We owe them proper accounting of any and all money, and we owe them reasonable care, or as the test will call that, skill. Okay, so we have to know when we are getting out of the area of being reasonable care and starting to go into some type of specialty, in which case I know my skill level stops at one point and I need to refer them off to a third party professional in that area. So remember, if I'm not an agent, I don't owe fiduciary duties. I will owe broker duties because I'm a broker. Okay, so we're not necessarily going to be an agent in everything we deal with. And actually, in most cases here in New Mexico, we are not going to establish an agency relationship. One you see most often, in which case we do establish an agency relationship, is something like property management. Because in property management, you are making decisions for the landlord. You are helping them lease the property. You're helping them do repairs. You're scheduling maintenance. You're scheduling maybe new carpet or new paint. You're dealing with the tenants in that area. But it's very important to the tenants that they know that you are a fiduciary of your principal, who would be the landlord in that case. And you do not represent the tenants, but the landlord themselves. Because again, remember that one of our fiduciary duties is loyalty to our principal. And anything that that tenant tells me is going to go back to my principal, because I owe them the duty of loyalty under my agency relationship. Now, if we're dealing in a non-agent, that's typically what we will see here in New Mexico. They'll deal as a transaction broker, in which case they are just a facilitator of the transaction. You're going to want to remember that word, facilitator, also known as an intermediary or a transaction broker of some sort, right? The transaction broker does not owe fiduciary duties to their principal, but they owe broker duties to their client. And broker duties say that we're going to abide by all national, state, and federal and fair housing laws and anti-discrimination laws. And we're going to deal ethically and reasonably, but we don't owe the duty of obedience and loyalty to our clients. And it's very important that the general public understand, when am I an agent and when am I not? And what are my duties to you if I'm not an agent? Okay, so non-agents act as facilitators. The other really confusing thing about agency is two areas. Number one is when you are a dual agent, meaning you're an agent of the buyer and the seller, then you also become a facilitator and you lose the fiduciary duties of loyalty and obedience. And that's because we cannot be loyal or obedient to both parties at the same time. So when we have the rare case of dual agency, where we have a signed agency agreement with the buyer and the seller, they both have to consent to this relationship. And now, instead of me being an agent where I owe all of my old car fiduciary duties, obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care, I am now a dual agent. So I'm acting as a facilitator, kind of a third party in this transaction, just helping you guys through the process. But I don't owe either of you loyalty or obedience. The second really confusing area of agency is one in which we actually go through and sorry, I just completely lost my train of thought here. But anyway, going back through it, remember that non-agent is the same as transaction broker, and that agency is created with our agency relationship. So there's a time that we might just be a third-party transaction broker. But when you're thinking of agency, just start thinking of maybe property managers, because that's the easiest connection to kind of film through. Now, typically when we talk about agents, those are people authorized to act on behalf of their principal with any third party. So again, property management, right? We're acting on that landlord's behalf and dealing with tenants, which are going to be the third party that comes through. And don't forget the differences between customer, client, and principal. Okay. Now, when we talk about express agency, that just means we have an express agreement to actually enter into a contract on behalf or with our principal. So express agency is our actual express agreement. And this is typically put in place with things like our listing agreement or our buyer representation agreements. That's when we're actually signing the agency agreements to commit us to having those fiduciary duties. Now, once you do those fiduciary duties, remember there's a lot more liability than just becoming a facilitator or a transaction broker, in which most people do. This was the other area of confusion that I was talking about earlier before my train of thought kind of flew off the tracks there. Implied agency. Now, implied agency occurs when parties act as though they possibly consented to agency. So if you're acting as an agent, you would have implied agency. Important thing to remember with implied agency is that it is not legal in most states. So a question you'll get on there will typically talk about how it's not legal in all the states. But if you enter in, let's say you're running an open house and a buyer or potential buyer or customer comes in and they ask you questions about the real estate market, and you start answering questions for them and giving them advice on properties and houses, you could have created an implied agency agreement with that person, and they are now your principal, even though you didn't sign a contract with them or give an express agreement with that person or have a buyer representation agreement with that person, you could still have the implied agency come through. So this is a really good example that it goes over for implied agency, and that's one of the hardest ones for people to grasp because it is not legal in most of the states. So don't forget about implied agency, and watch on the test if it talks about broker or agent. If it's talking about broker, it means a qualifying broker. If it says the term agent or principal, it's talking about an actual agent with an agency relationship, in which case you would owe those fiduciary duties. Now, here are those fiduciary duties that we talked about, and they do a different kind of memory tip. I like old car rather than cold AC, but you can do whichever one makes most sense in your brain. And there we see the care, obedience, loyalty, disclosure, accounting, and confidentiality that we talked about earlier. The next area is just kind of go over what those actually are. And remember with disclosure that we owe disclosure to the general public on areas that impact the actual property itself. Now, the next thing we're going to go over is the different types of agents, because there is very different types of agents and agency. The first one is a universal agent, in which case a person's empowered to do anything that the principal could do personally. And we typically see this as a power of attorney, because a universal agent is acting as that person. If I gave my wife universal agency or power of attorney over me, she could transact business on my behalf. She could open accounts in my name. She could purchase properties in my name. She could sell my properties. She's my universal agent. She has complete and total control over anything we would appoint her for. This could also be court-appointed guardians. Remember that if the court comes through and says we need to appoint a universal agent, that person will now have control over any properties, real or personal, that that person needs to sell. Now, general agent means we can represent our principal in broad ranges of business activities typically. And remember that the scope of our agency is set forth in our listing agreements or our buyer broker agreements that shows exactly how much power I have as a general agent. Right. So a property manager is a general agent. They can make some choices on behalf of that principal, but they're still limited to the scope of that agency relationship that we have established through the agreement. Then we have one called special agent, and special agents, also known as limited agents, represent the principal in one specific act or business transaction, only one. Okay, so they have a very, very limited scope of responsibilities and areas that they can commit their principal to. And that's also going to be listed in the agreement that we have with our principal. Now, remember, a really important part of agency is we absolutely have to disclose not only the parties we represent, we also have to disclose what fiduciary duties are and when we owe them. We have to be able to describe the difference in dual agency on when I owe those fiduciary duties, which ones go away. And I also have to disclose to the other party that I am already representing somebody in an agency manner as soon as possible. Because remember, one of our biggest duties in agency is loyalty. So if I have somebody come in as a tenant and they tell me that they're willing to pay more for a property or they're willing to do something that my principal would really like, I have to go back to my principal and report that to them because I owe that duty of loyalty. I don't have any agreement with that customer that's coming in. So remember, really important areas to see the differences between is customer, client, and principal, and when I owe fiduciary duties or not. Now, I know that's a lot of overwhelming information, and this can get really, really confusing. But another area that I would really pay close attention to is opinion versus fact, because there's a lot of the times where the general public takes our opinion and thinks of it as actual facts, and that can get very, very dangerous very quickly. So we want to make sure we're telling people when it's our opinion or when it's facts. But if you have an agency relationship, your opinions can become part of the facts for the transaction. So it's very important that you watch how you talk to your customers, clients, or principals, and exactly what you're saying, and you understand the scopes of your agreement and the limitations to your expertise. Also remember that your E&O insurance will not cover fraud or negligent misrepresentation, which just means something you should have known about it or you did know about it and you lied about it. And E&O is our errors and omissions insurance, which we are required to have. Now, a couple other items I'm going to touch on before we end this module. Number one is stigmatized properties, and stigmatized properties could also be called psychologically impacted properties. And those are areas where we had somebody commit suicide or pass away in the home, or we had somebody that lived there with HIV or AIDS, or something of that sort. Now, those stigmatizations are not required to be disclosed, and each state has different standards of what becomes stigmatized property, but that's part of our confidentiality. So we don't have to disclose any areas that might be, were impacted by somebody that passed away or committed suicide or had a homicide in that building. Now, I will say there's a caveat to that disclosure. And if there was a biohazard on the property, we do have to supply the facts that show the biohazard was properly remediated. So if somebody was there for a very long time and the bodily fluids seeped into the trusses, the floor itself, the walls, anything of that sort, we have to have a third-party company come through and biohazardly remove that those items. The other one to talk about is Megan's Law, which just requires states to make available to the public any persons convicted of sexual offenses in the community. So that's not something we're going to disclose that, hey, there's a sex offender over on this house. We give them the information to the sites, and if they would like to do their due diligence and look and see where people live that are on that list, they are allowed to do that. And I will say when they share that list, there's going to be lots and lots of red dots. And that's just what happens because remember, under sexual offenders, it may not just be something that was really malicious. It could be something of the sort like, hey, two 18-year-olds got caught doing stuff in the car where they're not supposed to in the public, and they had to register as sexual offenders for public nudity or something of that sort. So you want to be careful that you're not over disclosing things that you don't have to disclose, but you still know where to find the facts and direct your client, customer, or principal in order for them to do their own due diligence. Now, really, really important to remember is your fiduciary duties and what they are. Those are going to be on the test questions. You'll want to know the differences between agency, transactional brokerage, and when you become a facilitator. And that's pretty much all we're going to touch on today, so you're not completely overwhelmed. But again, if you have questions about this module, we'll be going over this in some live office hours, or you can send me an email and we can try to do a one-on-one Zoom or answer questions over that email. Just allow 24 business hours for me to get back to you. I hope your brain isn't exploding by all of this, but if it is, don't worry. So is everybody else's. This is a lot of content to try to go through in 10 weeks. But take your time, go through and make sure you have all of these vocabulary words memorized and you can at least identify what each one will mean. Hope you all have a great rest of your day, and we'll see you on the next module.